Why probation? Is it an alternative to imprisonment? Let us try to get the answer. If we look into Bentham's philosophy of punishment, theory of punishment, Bentham started that we should look into the evils of punishment also. So reformation, where possible, we have to think, because all punishments are evil in itself. So reformation of offenders has its objective value from 19th century onwards. Moreover, if we look into the statistics, it is revealed that probation is less recidivism than imprisonment. In imprisonment, the prisoners' recidivism rate in India varied from 5 to 6, whereas in probation it is within only 1 or 2%. Moreover, to avoid overcrowding in prison and community correction, probation can be taken as our most accepted form of correction or punishment. Present trends is non-institutional correction, and to that sense probation is also welcome to our criminal justice system. And finally, there is inherent self-correction process, for which probation is very much essential in criminal justice administration. If we look into Indian legal system and Indian laws, there are varied processes of probation in India. Under section 3 of Probation of Offenders Act 58, there is a provision of admonition, which is a verbal warning to the offenders. There is provision of section 4 in Probation of Offenders Act, a system of probation where offender can be released and extended benefit of probation, which may extend to 3 years, and if no offence committed, he is not to go to jail or to have any other punishment. We have also from 2006 amendment of Criminal Procedure Code, under section 265E, within plea bargaining there is a provision that if the parties to the plea bargaining agreed to have probation as alternative to any punishment, the court can grant the extension of probation to the offender. We have also in our Juvenile Justice Care and Protection of Children Act 2000 the system of probation. Under section 15E and F, provision of probation provided for juveniles who are in conflict with law. Let us look into what is admonition. Section 3 of the Probation of Offenders Act, as we have already learned, provides the provision of admonition, which is a verbal warning or condemnation on minor offences. And who can get that? First offenders, circumstances of the case, considering circumstances of the case, the court can think, also the nature of the offence and character of the offender. Particularly when offence be one of the following descriptions of IPC, like 379 theft, 380 theft in dwelling house, 381 theft by clerk or servant, 404 misappropriation of the property, or 420 cheating under IPC. And any other offence, if punishable with imprisonment for not more than 2 years, or with fine, or with both, under Indian Penal Code or under any other law for the time being in force, the court can grant admonition, court can release the offender by verbal warning. Now let us look into circumstances or cases where admonition granted by court in India. Very first case where principles of and guidelines of admonition declared by court, we can look into B.C. Kishan Sona versus State of Odisha, where the judge categorized the classes of cases or circumstances where court can grant admonition. For example, in case of Sitaram Sali versus State of Maharashtra, the Supreme Court, in a case where an employee of a railway convicted for committing theft of coal worth ₹8 only, convicted and dismissed from service, the court held that he may be treated under section 3 or 4 of the Probation of Offenders Act. Similarly, Anil Kumar Pandey and another versus State of Bihar, where two brothers on a dispute of their property and land demarcation involved certain quarrel and also caused injury, the court granted the benefit of admonition under section 3 of the act and dismissed the trial court as well as the high court's conviction and sentencing to jail. Now if we look into the probation under section 4 of the PO Act, the first thing we have to remember here, unlike admonition, except offence which are punishable with death or life imprisonment, any other offence either in the IPC or any other special legislation except Prevention of Corruption Act, any offender can be considered by the court for release under probation of good conduct under section 4. And what the court will look into? The circumstances of the case, character or antecedents of the offender, age of the offender, and also the pre-sentence investigation report or PSI report submitted by the probation officer. And to use this discretion, how the court in various situations applied the principles seen in section 4, we may look into few cases. In Ved Prakash versus State of Haryana, the Supreme Court held that wherever there is a provision of giving or extending benefit of probation, the court should not act mechanically. Court should look into the circumstance of the case and extend the benefit of probation instead of sending the offender on jail. In Saradakar Sao versus State of Odisha, the Odisha High Court observed that for standing or by trespassing land between residence and a temple, a very minor offence, for that probation is the fit punishment for the offender. Similarly, in Amini versus State of Kerala, the Kerala High Court observed that where a woman having husband and the sole earning member carrying illegal liquor and convicted under Abkari Act is a fit case to be released on probation. But in State of Maharashtra versus Kapurchat Kesarimal, where the young offender carrying huge quantity of gold, or Dalbir Singh versus State of Haryana for accident under section 304A, or in Sanjeev Nanda versus State of NCT, where there is attempt of kidnapping, or Gitaram, another versus state of Himachal Pradesh, where the offence was showing of blue film to young generation. The court held these are not fit cases for extending benefit of probation. In fact, if we look into various cases, it can be identified there are some mitigating circumstances for granting admonition or probation by the court, such as age of the offender, economic condition or means of livelihood, first offender or offence committed spur of moment, or provocation, temptation, absence of bad intention, or self-preservation or preservation of nearest one,